Is justice for sale in Texas? Some recent headlines might make you wonder. The Wall Street Journal has called the decision of one Texas court a national embarrassment. The New York Times editorialized that the conduct of the Texas courts is reminiscent of what passes for justice in small countries run by colonels in mirrored sunglasses. What triggered this barrage of criticism? The Texaco-Pennzoil dispute and the $10.5 billion verdict that a Houston jury rendered against Texaco. A verdict permitted to stand last month by the Texas Supreme Court. But the issue at the heart of the controversy is not which of the giant oil companies should have won the case. Instead, it is about the fact that in Texas, where judges are elected to office like politicians, their biggest campaign contributors are the lawyers who practice before the very judges they help elect. One such judge has now decided the system is just plain wrong. He is the current Chief Justice of the Texas Supreme Court, John Hill. Give us a sense of the money factor, the magnitude of it. How big is it? How much money are we talking about?
It's outrageous. We're to the point now where it costs about $1.5 million to run a successful race for the Supreme Court of Texas.
Even though Judge Hill himself has relied on lawyers' contributions, he is so disturbed by the perception that money is corrupting Texas justice that he is resigning from the court to lead a fight to end the election of judges and to get money out of the system.
This would shock people if they really knew what the people that study these things do know. It's what I know, and it upsets me, and I want to change it.
Where does the money come from?
Largely from lawyers who practice in the court.
Case in point, Joe Jamail, the legendary Texas trial lawyer who represented Pennzoil and now prides himself on being the man who bankrupted Texaco.
What do you think about it all, Judge? How are you?
Fantastic.
Jamail is not only Texas' preeminent trial lawyer, he is also one of the most generous contributors to judges' campaigns. He gave us a glimpse of the relationship between contributing lawyers and Supreme Court justices when we accompanied him to a conference of judges in Corpus Christi last September.
Excuse me, Judge. Yes, sir. I want to go see Campbell for a minute.
Jamail is referring to Supreme Court Justice Robert Campbell. Since the Texaco-Pennzoil case landed in the Texas courts, Jamail has contributed $22,500 to Judge Campbell's campaign.
Hello, Judge. How are you? I'm wired up for 60 minutes.
That makes him one of Judge Campbell's biggest contributors.
And I'll be in touch.
All right.
The man Jamail is talking to is Supreme Court Justice William Kilgarlin.
Well, Joe hadn't given me any money lately. As a campaign contribution or otherwise.
And that may still be the case this year. But last year, Jamail gave the judge $7,000 for his campaign.
I'd like to say hello if you could tear yourself away for a minute.
Your Eminence.
The next judge Jamail spoke to was Supreme Court Justice Oscar Mousy, one of whose biggest campaign contributors is Joe Jamail. And so the lawyers are just interested in good government, in good justice here in Texas.
Well, I think you have to talk to every individual to find out. There may be some individual somewhere who may have a private slant. I'm pleased that over half the people that contributed to me last year were not lawyers. There are people who've known me a long time. And
in numbers?
In numbers, that's right.
Of people?
Yes.
But in dollars, of the $1.5 million, most of them were lawyers.
I'd have to look at my financial campaign reports to see.
I have.
Okay.
And most of them were law firms and individual lawyers. Among them, of course, your good personal friend, Joe Jamail. Correct?
Well, as I say, the report speaks for itself. And please understand, we're not permitted under our canons of ethics to discuss any judge or any lawyer or any case that's presently pending.
Joe Jamail was not so circumspect when we asked him in Corpus Christi what people should think about his large campaign contributions to Judge Mousy.
Well, who else would help? I know him about as well as anybody. I know what his philosophy is. You know, is he going to go to his enemies and they're going to give him campaign contributions? That's bullshit and naive. You know it and I know it. And tell me, first off, our laws permit this, and not just in Texas, but every elective state that uses the elective system. So I don't know what they think. They would think he'd be a fool if he didn't ask. Incidentally, he never had to ask.
And how much did Jamail give?
I don't remember what it was. I think it's $25,000. It may have been more. I think it's $25,000. But you see, that's not unusual for me. I think that's the same contribution I've given to all of the Supreme Court justices, Gonzalez, everybody.
Actually, Jamail gave Judge Mousy some $45,000 and was one of a group of lawyers who guaranteed a $225,000 loan to the judge.
To run for a statewide office, now, as you know, with television and what have you, requires a good deal of money. Most of that money, I'd say 95% of it, comes from lawyers. Because the citizen isn't gonna, he doesn't particularly give a damn.
I think the giving and the acceptance of these unseemly sums of money is wrong.
Judge Jack Pope retired as Chief Justice of the Texas Supreme Court 3 years ago. One would think that common sense indicates the justices, the judges, are going to look kindly on those lawyers who have given them the biggest contributions.
Mr. Wallace, I'm not defending the system. I'm just reporting to you what the facts are. Pigs is pigs.
Does the Texas Supreme Court have a credibility problem in the Pennzoil Texaco case because of the massive contributions given by lawyers on both sides?
Well, I suppose anybody can answer that question. And
Sounds like you're saying you're damn right.
Well, I am saying that if I were walking into the courthouse to try a lawsuit before a judge that I knew had been heavily financed in a successful campaign, I would be worried about the case.
Case in point. During the Texaco Pennzoil case, Joe Jamail, representing Pennzoil, gave a $10,000 campaign contribution to the original trial judge, Anthony Farris. Jamail's contribution to the now deceased Judge Farris was given just 4 weeks after Judge Farris had been assigned the case. Judge Farris himself, in this letter, called the $10,000 contribution a princely sum, and he sought Joe Jamail's help to raise more money. Well, as the case proceeded, Jamail did just that, soliciting his lawyer friends to pony up at least $1,000 apiece to Farris' campaign. Texaco, citing the size, nature, and the timing of these contributions, attempted to disqualify the judge. But Judge Farris successfully argued, to Texaco's astonishment, that, quote, mere bias or prejudice is not grounds in Texas for a judge to disqualify himself. When the jury returned its unanimous verdict, Pennzoil and Jamail emerged victorious, the winner of the largest jury verdict in history. Texaco promptly appealed. And when the appeals court turned them down, they moved to the court of last resort in Texas, the Texas Supreme Court. But by this time, the court itself was the object of a legislative investigation into the relationship of certain justices to their major campaign contributors, especially Supreme Court Justice C.L. Ray. State Senator Frank Tejeda led the investigation. Tell us about C.L. Ray. What kind of a man?
Well, the Commission on Judicial Conduct found him guilty or liable on 7 instances. And we're talking about favoritism for free plane rides, solicitation of funds, other ex parte communications with party litigants, not only with the attorneys, but with party litigants. And in one
Senator Tejeda is talking about an encounter between Justice C.L. Ray and this man, Houston millionaire Henry J. N. Taub, at a fundraising event for Justice Ray. At the time, Taub had a multi-million-dollar case pending before the Supreme Court. Justice Ray had set out invitations to lawyers and their clients to bring $1,000 each and come to his fundraiser in Houston. When Taub appeared, Judge Ray approached him. He, the judge, takes you, Mr. Taub, aside at a cocktail party and says to you just what?
He said to me that the case was a difficult case, the case that was involved, my case before the Supreme Court that he was sitting on.
Right.
And that if I did not win this case, the next case would be mine.
Now, wait just a second. A judge of the Supreme Court told a litigant in front of that court that he wasn't sure that you're going to win this one, but you'd win the next one, in effect.
Mr. Wallace, I reported this under oath to the Select Committee in Austin. It's part of the record.
The investigation of the court and the unprecedented rebuke of 2 sitting justices by the State Judicial Commission was based on the testimony of several of these Supreme Court law clerks who testified about the misconduct they had witnessed. The judge's response to the testimony of the court's own law clerks was to initiate a libel action. Both Ray and Kilgarlin raised money for this libel suit by, in effect, dunning lawyers around, or asking for contributions from lawyers around the state.
That's correct. They sent out over 4,000 solicitation letters to attorneys throughout the state. Many of those attorneys had cases pending at that time before the Supreme Court. Many of those attorneys called me as chairman of the Committee on Judicial Affairs, wrote to me, wrote to the Commission on Judicial Conduct saying, look, I despise this, I detest this, I want to complain. What am I to do? I've got cases pending. If I don't contribute, it's going to adversely affect me.
A number of former law clerks told us about the conflicts of interest they had seen, but only Jeff Armstrong was still willing to speak out publicly.
It bothers me and it makes me angry that their tactics to intimidate people from talking, to keep from telling what they know about their misconduct has succeeded so well that nobody will talk about it anymore.
The central question in all this, a question frequently raised in Texas political ads like this one, is whether money, campaign cash, does in fact influence judges' votes. Consider just one vote of the judge who is today running to become Chief Justice of the Texas Supreme Court.
Ted Robertson, a judge to be proud of.
The case before the court involved Judge Robertson's main campaign contributor, Texas oil millionaire Clinton Menges, who had given the judge over $120,000 in contributions at a time when Menges had a major case before the court. Initially, Robertson said he would not vote on the case, but he changed his mind when the then Chief Justice announced that for want of one vote, Mr. Menges was about to lose.
When that happened, he then reconsidered, and he did vote.
How long did it take him to reconsider, Judge Poe?
About as long as you and I have been asking the question.
In other words, Robertson changed his mind.
In a heartbeat, he did. And after that, there was this sort of quiet that settled over the room while everybody tried to figure out exactly what had happened.
And they realized what had happened, that this man, in effect, seemed, at least, to be voting his pocketbook instead of his conviction.
I think if you had taken a poll of the people in that room that day, that's exactly what you would have found out. I don't think somebody's conscience changes that quickly.
A year later, when the case came under review and his vote was no longer the decisive one, Robertson voted, with 7 other justices, against Menges. Because he declined to talk to us, we were unable to ask him why, when the court's decision had hung on his one vote, he had sided with the man who had contributed $120,000 to his campaign. Fact is, none of this is illegal under Texas law.
That's the very disgraceful part, and the thing that we have to take the initiative and change.
Judge Mozzie, let's say that Joe Jamail or almost anybody has given you a big campaign contribution, and he comes before you. Well, let's say he's given you $50,000, and he comes before you with a case. Do you feel no obligation to recuse yourself, to take yourself off that case?
No, I wouldn't feel any obligation to.
Because?
Because that contribution, I look on just like it was given to me. Anyone who's ever contributed to me knows this. That money's accepted to help me get elected to office. It is not accepted for the purpose of influencing me on anything that I'm going to decide.
And as far as Joe Jamail, for instance, is concerned, if he gives you $50,000, it is for good government.
Well, you'll have to ask him what he gave it for.
Originally, Joe Jamail had agreed to a no-holds-barred interview, no conditions. But after our first day of filming with him, he had a change of heart. And since then, Mr. Jamail has been writing letters charging 60 Minutes with having misled him about the story we were reporting. He now suggests he never consented to discuss the Texaco-Pennzoil case with us. But in fact, before pulling out, Mr. Jamail had already talked to us about that case and about campaign contributions to Texas Supreme Court justices.
Texaco's lawyers, the ones that have taken it from since the time of the appeal, that's what they're really talking about, since the day of the verdict, okay? Have contributed substantially the same amount as the lawyers on the Pennzoil side. Rusty McMains, for instance, who's with Bill Edwards' firm when they were in it, we got it originally. I think that they had contributed more individually than I had. You can check it. It was at least as much.
Texaco's lawyers have indeed made sizable contributions since losing the jury trial, but to date, as best we can tell from the records, Jamail and Pennzoil have out-contributed Texaco by almost a 3-to-1 margin. Again, the sitting Chief Justice of the Texas Supreme Court, John Hill. $750,000 has been given to the variety from both sides, both Texaco and Pennzoil, to various judges. Does this not corrupt the process? Does it not stand a chance of corrupting the process?
I think, again, that it's perceived by people. They look and see the amounts of money that have been given by litigants, be it these two litigants or others. They focus on that. They wonder why. They get confused. They read stories. It breaks down confidence.
There may be so much taint, deservedly or undeservedly, because of the large amounts of contributions that have been given by both sides, but particularly by Pennzoil attorneys, that I think no matter what happens in that case, the perception, the appearance will always be there that it was bought by one side or the other.
On November 2nd, the Texas Supreme Court turned down Texaco's appeal. Texaco is now preparing a final appeal to the United States Supreme Court in Washington.